And today our topic for discussion is fundamental rights. So dear students, as we know that the fundamental rights are enshrined in part 3rd of the Indian Constitution from Article 12 to 35. The fundamental rights concept, it was borrowed from US Constitution. It was in US, it is known as Bill of Rights. So according to B.R. Ambedkar, it is the most criticized part of the Indian Constitution. Fundamental rights are the most criticized part of the Indian Constitution according to B.R. Ambedkar. As we know that the fundamental rights are, it was finalized by Sardar Vallabhbhai Patel Committee. Sardar Vallabhbhai, as we know, is known as the Iron Man of India. Sardar Vallabhbhai Patel Committee finalized fundamental rights. We see that the fundamental rights, they are mentioned in part 3rd of the Indian Constitution. That's why we see that part 3rd of the Indian Constitution is known as the Magna Carta of India. Fundamental rights are guaranteed by the Constitution to all persons without any discrimination. So fundamental rights are, they are meant for promoting the ideal of political democracy. Fundamental rights are so important that the Constitution itself ensures that they are not violated by the government. So judiciary has the power and responsibility to protect the fundamental rights from violations by actions of the government. However, we see that fundamental rights are not absolute. They are not absolute or unlimited rights. Government can put reasonable restrictions on the exercise of our fundamental rights. So fundamental rights are, they are enforceable by the courts subject to certain conditions. We see that fundamentals are, they are justifiable in nature. So far the word justifiable is concerned, we see that in case of violation, a person can approach, in case of violation of fundamental right, a person can approach a court of law. So court is responsible for the enforcement of fundamental rights for their violation. In the original Constitution, we see there was a group of 7 fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right to property, and we see the right to constitutional remedies. So dear students, but we see that the present we are enjoying 6 fundamental rights, because the right to property, once it was a fundamental right in original Constitution, it was deleted from the list of fundamental rights in the year 1978. In 1978, through 44th constitutional amendment. The right to property was deleted from the list of fundamental rights. Now it's a legal right. Under Article 300A. In Part 12 of the Constitution. Right to property is now it's a legal right. So we are enjoying only now. We have only 6 fundamental rights. First, right to equality from Article 14 to 18, right to freedom from Article 19 to 22, right against exploitation from Article 23 to 24, right to freedom of religion from Article 25 to 28, cultural and education rights Article 29, 20, 30, and right to constitutional remedies Article 32. As we know that this part 3 is also known as the soul and the very heart of the Indian Constitution. So for the Article 12 is concerned, we see that the fundamental rights are enshrined in part 3rd of the Indian Constitution from Article 12 to 35. So for the Article 12 is concerned, we see that this Article 12, it explains the state. We see that the state includes government and the Parliament of India, government and state legislature, all local bodies, municipalities, panchayats, and district boards. So we see the Article 12, it explains the state. So far the Article 13 is concerned, we see that this Article 13, we see that it is through Article 13, this Constitution, it prohibits the Parliament and state legislature that they may take or abridge the fundamental rights guaranteed to the citizens of the country. We see that Article 13 is the basis. It is the basis for judicial review. This Article 30, it gave Supreme Court and High Courts the authority to interpret the pre-constitutional laws. Now, the first fundamental right is the right to equality. So far, the Article 14 is concerned. We see that Article 14, it talks about equality before law. It talks about equality before law and equal protection of law. Article 14 talks about Article 14, it talks about equality before law. Article 14 talks about equality before law. Equality before law and equal protection of law. So far, the equality before law is concerned. We see that all people should be treated equal before law. No one is above the law. This equality before the law is known as rule of law. As we know that we have taken this rule of law from UK Constitution. हमने कहाँ से लिया? UK Constitution से लिया rule of law concept को. Rule of law means that all people, irrespective of their caste, color, gender, creed, they are equal. They are equal before law. No one is above the law. And equal protection of law. And equal protection of law means we see that the equality of treatment in equal circumstances. Equality of treatment in equal circumstances is known as equal protection of law. We have taken the concept of equal protection of law from US Constitution. So Article 14 talks about what? Equality before law, also known as rule of law. So far the Article 15 is concerned. Article 15, it talks about prohibition of discrimination. No discrimination on the grounds of religion, caste, color, creed, sex, region, religion, place of birth. No discrimination. Clear? So we see that the Constitution prohibits discrimination. Clear? Under Article 15, no discrimination. Everyone is equal before law. You cannot discriminate a person on the basis of his religion, on the basis of his caste, on the basis of his color, on the basis of his sex, on the basis of his region. Clear? Or we can say that on the basis of his religion. So before law, everyone is equal. So Article 15 talks about prohibition of discrimination. So far the Article 16 is concerned, it talks about equality of opportunities in matters of public employment. In matters of equality of opportunities, all people have opportunity, either rich or poor, they have opportunity in the matters of public employment. So far the Article 17 is concerned, we see that Article 17, it talks about abolition of untouchability, and we see prohibition of its practice. Abolish of untouchability and prohibition of its practice. As we know that the practice of untouchability is one of the crudest manifestations of inequality. It was, we see that from ancient times, we see that Indian society was a caste-ridden society. We see that this untouchability was followed in Indian society from ancient times. Now the Constitution clearly mentions that there is no ground for untouchability. So that's why we see Article 17 talks about abolition of untouchability and prohibition of its practice. So far the Article 18 is concerned, we see that Article 18 it talks about abolition of titles except military and academic. So आज के वीडियो में बस इतना ही. तो नेक्स्ट वीडियो में हम डिस्कस करेंगे राइट टू इक्वालिटी के बारे में. सो डियर स्टूडेंट्स, वीडियो को देखने के साथ साथ चैनल को सब्सक्राइब करना ना भूलें.